NASCAR's legal battle against Michael Jordan's 2311 Racing just took a dramatic turn that could change everything. The racing governing body has filed a motion to amend its counterclaim, dropping what they call indisputable evidence against the team co-owned by NBA legend Michael Jordan and current driver Denny Hamlin. This explosive new development centers around NASCAR's claims that they've discovered damning proof within over 200,000 pages of communications. These documents allegedly show 2311 Racing and Front Row Motorsports engaged in illegal collusion with other teams. The timing couldn't be more critical as both sides prepare for a December trial date. What exactly did NASCAR find? According to their filing in the United States District Court Western District of North Carolina, Charlotte Division, the evidence contains emails, texts, and memoranda that NASCAR claims indisputably confirm their allegations against the teams and Jordan's business partner, Curtis Polk. To understand the significance of these new claims, we need to look back at how this fierce legal battle began. The conflict started in October 2024 when 2311 Racing and Front Row Motorsports filed an antitrust lawsuit against NASCAR. The teams alleged NASCAR engaged in anti-competitive and monopolistic practices through its charter system. This system, which guarantees team spots in races and certain financial provisions, became the centerpiece of a bitter dispute when both 2311 and FRM refused to sign NASCAR's Take It or Leave It charter deal for the 2025 season. While 13 other teams signed the agreement by the September 20th, 24 deadline, Jordan's 2311 and Bob Jenkins' Front Row Motorsports held out. Their refusal set off a chain of legal maneuvers that has now escalated dramatically with NASCAR's latest filing. The charter system represents NASCAR's attempt to create stability for teams through guaranteed race entries and financial provisions. Essentially, teams with charters receive guaranteed spots in every race and benefit from a predetermined share of revenue. Both 2311 and FRM argue that this system, as currently structured, suppresses fair competition and allows NASCAR to monopolize the sport. The teams believe the financial model is inequitable and fails to provide them with a sustainable business structure. For context, under the most recent charter agreement that other teams signed, NASCAR claims teams would receive approximately 49% of revenue from the new 7-year, $1.1 billion average per year media rights deal. That's up from 38 to 40% in the previous agreement, according to NASCAR's attorney Chris Yates. In March 2025, NASCAR responded by filing a countersuit against the teams. They branded 2311 and FRM an illegal cartel and alleged they had willfully violated antitrust laws through orchestrating anti-competitive collective conduct. NASCAR specifically called out Curtis Polk, Michael Jordan's longtime business partner and 2311 co-owner, as the ringleader of these efforts. This accusation prompted Jordan to claim the lawsuit had become personal. Now, with this new filing on April 18, 2025, NASCAR claims to have concrete evidence supporting these serious allegations. They're asking the court for permission to amend their counterclaim to include excerpts from these recently discovered documents. What exactly does NASCAR claim to have found? According to their filing, the documents show that 2311, Front Row, and Curtis Polk knowingly entered into illegal agreements with other teams on several critical issues. These alleged agreements involved fixing the compensation that they received from NASCAR, allocating how that compensation would be divided among the co-conspirator teams, using Jonathan Marshall of the Race Team Alliance as a conduit for these activities. NASCAR's filing goes further, stating, although its existing counterclaim more than adequately states a claim for relief, NASCAR seeks leave to file an amended counterclaim that includes excerpts of these recently produced documents because they confirm, beyond any doubt, that 2311 and Front Row reached unlawful agreements with each other and other teams, and that Curtis Polk was the ringleader. The sanctioning body claims Polk led efforts to set compensation received by the teams, boycott NASCAR events, interfere with NASCAR's negotiations with media partners, and reach unlawful agreements. The response from the teams was swift and forceful. Attorney Jeffrey Kessler, representing both 2311 and Front Row Motorsports, dismissed NASCAR's new claims as a meritless distraction and a desperate attempt to shift attention away from its own unlawful, monopolistic actions. NASCAR's response to our motion to dismiss and their need to amend their counterclaim further demonstrates the weaknesses in their arguments, Kessler stated. As we have said before, our original lawsuit has always been about transforming NASCAR into a more competitive and fair sport for the benefit of drivers, fans, sponsors, and teams who love the sport. These filings change nothing, and we look forward to presenting our case at trial. This response highlights how the teams view NASCAR's counterclaims as a strategic legal maneuver rather than a substantive allegation with merit. An interesting subplot in this legal drama involves the team's efforts to obtain financial information from other major sports leagues. In early April, 23XI and FRM went to court to enforce subpoenas issued to the NFL, NBA, NHL, and Formula One. The teams hope to compare each sport's financials to NASCAR's model. According to their filing, this information would enable plaintiffs to perform a yardstick comparison between the other major professional sports leagues, where competition is not precluded, and NASCAR, where exclusionary conduct has been used to unlawfully maintain a monopoly. The NFL strongly opposed this request, stating in its opposition that the subpoena is based on the flimsiest of premises, that because plaintiffs are suing NASCAR, they can obtain, by way of federal process financials, financial projections, research, studies, analyses, and other highly confidential, proprietary, and commercially sensitive information belonging to almost every other major sports league in the United States. This battle for comparative financial data underscores a central question in the case. Is NASCAR's revenue-sharing model fair compared to other major sports? A significant victory for the teams came in December 2024 when the U.S. District Court Judge Kenneth Bell granted their request for a preliminary injunction. This ruling required NASCAR to allow 23XI and FRM to sign charter agreements they were offered in early September and approve the transfer of charters each team planned to purchase from Stewart-Haas Racing. To obtain this injunction, the teams had to prevail on 4 factors: likelihood of success. The judge ruled that the clause in the charter agreement releasing NASCAR of legal claims would likely be considered unlawful. Irreparable harm. The judge accepted that drivers could potentially leave the teams and sponsors might withdraw if they couldn't race as chartered teams. Balancing of equities. The judge determined NASCAR wouldn't be harmed by the injunction, while the teams would suffer significant harm without it. Public interest. The judge stated, NASCAR fans have an interest in watching all the teams compete with their best drivers and most competitive teams. Further, the public has an interest in preserving the rights of litigants to pursue legal claims in good faith, particularly antitrust claims that aim to preserve the process of commercial competition. NASCAR appealed this ruling with a hearing set for May 9, 2025 in the U.S. Court of Appeals in Richmond. NASCAR legend Jimmy Johnson has weighed in on what he thinks the sport will look like after this legal battle concludes. During an appearance on the Business of Sport podcast, Johnson shared he expects NASCAR to evolve toward a structure more like other sports leagues.
So this year, we're going to Mexico City for the first championship points paying event for the top series ever. It took one of the races to Chicago. There's a street circuit in downtown Chicago. So as we look forward, and there's some rumors about NASCAR someday selling a portion off and becoming more of a league. And we're all waiting and think that there's a real potential there. And as we become a league, that's when all ships in the harbor, I think, will rise more.
Johnson believes NASCAR has a long way to go to reach the same heights as other American sports leagues because of the slow evolution in the sport. Comparing the situation to recent changes in other sports, Johnson added,
And the more I dig in, the more I understand this just happened in Formula One. This happened not long ago in the NBA, and I just think we're following the same trajectory where it's going to become a proper league and it has to evolve.
NASCAR's core defense against the antitrust claims involves challenging the definition of the market itself. They argue that defining the market as just cup racing is too narrow for antitrust purposes. Instead, NASCAR contends the relevant market should include all motorsports or even the broader sports landscape. This distinction is crucial because antitrust law focuses on whether an entity has monopoly power within a defined market. The teams, conversely, maintain that NASCAR Cup Series racing is its own distinct market. Judge Kenneth Bell appeared to agree with this position, writing in his injunction ruling that the availability of multiple sports in the United States says nothing about NASCAR's control of a major one of them, in the same way that the availability of professional basketball and football did not lead to a finding that the NCAA was not a monopolist with respect to the highest levels of college basketball and football.